Members are actually at court this morning trying to put an interdict against that very conference which is underway. Currently, Limpopo is giving some of the arguments being brought forward.
Wrong decisions taken by the PEC can influence the outcome of the conference. Hence, it is important that the PEC must function lawfully. Even the venue and other logistics are determined by the PEC. All invitations are issued by the PEC and not by the branches. What is that? There's a conference in Pulugane organized by the branches. That's just it's almost like saying nothing. As we say, even mundane things such as the branch, the program, this and that, and is determined by the PEC. So, at the heart of this conference that is taking place is this is the stamp of this illegitimate PEC. Nobody else is there. Nobody is running the show. Nobody is the so-called branches are actually dependent on the PEC. Even if it was a PTT correctly, it would still be the same. But that's just logical in the sense that a regional conference would be run by the regional structure. Whether it's an RC or RTT for that reason is not important, but it will be. And the national conference, as we heard in Nazareth, is run by the National Executive Committee.
Is there any provision in the Constitution?
Yes.
What law? Which clause or rule they call them rules?
Of what a provincial conference is. Yes, there is. I will come to it, Malik. But for now, let's. The overall point I'm making is that the mandate that was being given and the everything about the conference has got the stamp of the illegitimate PEC. So if we are right, which you must assume now, if we are right that that PEC is non-existent and it's long expired, then the thing that is happening now is being run by a bogus body, or I don't know how to.
But there's a constitution. I can't just accept, even if I have regard to your version only. If it's issues that are in the constitution, I am guided by the constitution.
Yeah. No, your ladyship can even be guided by the program. That's what I said. Just all you have to do is look at the program, and you'll see.
Let's start with the constitution.
Running. Yes.
Let's start with the constitution.
All right.
Can you get that provision?
Yes, it's being. Yeah, 17. It's page 57, Malay.
Page 57 of the.
Oh, I'm sorry. Of the first bundle A. That's the Constitution of the ANC.
Yes. I'm there.
Yes. This is. It talks about the provincial conference. It's a subject to decision of the National Conference and National General Conference. Provincial shall be the highest organ of the ANC in each province. In other words, that's the determining body. The point that I've been making. In every province, the highest organ is the provincial conference. After the provincial conference, the next level is the PEC. It says the provincial conference shall be held at least every 4 years, and so on. That's irrelevant for something else. But let's go to 17.2.2.2, for example, which is at page 58. All members of the Provincial Executive Committee shall attend ex officio as full participants and as delegates to the conference. Just pause there. What that means is that the members of the PEC, of the illegitimate PEC for the purposes of this, because we have assumed that is so, will be voting delegates in the conference, first and foremost. And then it says, where the point is made very clear at number 2, that's the point we make in the affidavit, which leadership correctly says must be backed up by something in the Constitution.
Yes.
It says, the PEC.
Which
I'm sorry, it's Roman 2, after 17.2.2.3.
Non-voting delegates.
Yes. The PEC may invite individuals who have made a special contribution and so on and so on. The PEC shall permit representation to structures which do not have minimum requirement of a branch. Now, what does that show? It shows that any invitations to that conference for everybody, so to speak, come from the PEC. Now, if the PEC invites me, for example, to go to that conference, then I would never receive an invitation from a branch, for example. Some branch somewhere in Polokwane decides that they want to invite me. No, it's the PEC, because it's the PEC that is running the show there.
That's what I want to see, where it says the PEC runs the show. That's what I want to see.
It doesn't say runs the show.
In this constitution.
No, it will never say that.
It will not say runs the show, but then, because remember there's your prayers, you want to interdict the whole conference.
Yes.
Which is what we are actually debating.
Yes.
Then you want to interdict the participation of PEC members, which would be maybe a simple. It's clear there, but as to the whole conference, that's where I'm having a problem.
Yes.
Because now.
Yes.
Let's take it from there.
Let's take it from there. What was saying, my lady?
You're saying the PEC, there's this group of people, how many number they are, who illegal, and then who are now have been given a mandate to, I can't remember the words you used, but I recorded them here.
Oversee.
To oversee the conference. So that's the issue.
I understand, my lady. I understand.
So if it's an action or an order directed at this group of illegal people, I would not have a difficulty trying to find something against them.
Yes.
But as to the whole
stage.
conference,
I understand.
You understand what I'm
exactly.
yes.
My lady, the point we're making is simply this, as to the second leg. Your ladyship is quite correct. The first leg is simple. The second leg really should be understood in the following manner. Let's start with the negative. That conference that is happening now at Polokwane, now as we speak, did not call itself. That conference did not convene a venue, did not decide a date, did not decide which delegates have passed or failed, did not invite the delegates, did not invite even these non-voting delegates. All those things were done by something called the PEC. So we say somewhere in the papers, and I'll find the passage, when you fail, for example, let's say you don't have a quorum or whatever in your BGM, the people who are going to say whether, when we talk about credentials, if your leadership goes to the program, you'll see the first item is credentials in every conference of the ANC at any level. Who is determining those credentials? Who can say, Mr. Ngogaitobi, no, you are in or you are out? It's the provincial executive structure at a particular time.
Does it not say, I've seen a clause or a rule, as they call it, that who appoints the preparatory committee? I think it's the PGC.
No. Remember, the preparatory committee, is, if you like, is just a subcommittee of the PEC. It's just an ad hoc committee for a specific purpose, which is just in other words, to make sure that is not the whole PEC is going to go and ask for a venue or T-shirts and so on. So there's a preparatory committee. It's not a constitutional structure. It's simply a what do you call it, event organization thing. Yeah. So
it says here, The provincial conference shall appoint a conference preparatory committee which shall circulate conference information in advance, determine the procedure for the selection of delegates, and indicate, I'm reading 17.2.2.5.
Yeah.
That's not the
Yes.
PEC.
My lady, maybe if I can suggest a shortcut.
Yes.
Your ladyship can go to 19.1 at page 59.
Before I go there, I just want you to agree that what I'm reading is what's written here.
I'm sorry, my lady. Where was your
It
ladyship?
comes from Rule 17, Provincial Conference.
Yes.
And what the Provincial Conference does,
Oh, yes, the part
its
that was.
powers, and all I'm saying is that you and I were trying to figure out who, if I may use the word, organizes
Yes.
the conference.
That's correct.
And plans the conference.
Absolutely.
And to me, this sounds closest.
That's close, my lady. But if
Actually, it is not even close. It is.
it is very close, yes.
Yes.
Yes, but just to satisfy your ladyship even more, can you go to paragraph 19.1 at page 59?
19.1.
Yeah.
Now you're dealing with the authority of the PEC.
Yes.
Yes.
Just to show what between the language of my ladyship and me is who runs the show in the province.
Yes.
In the province. So they said the PEC is the highest organ of the ANC in a province between provincial conferences and has the authority to lead the organization in the province subject to the provisions of this constitution. All I'm saying is that, my lady, at a logical level, if that is the role of the PEC, so it's like the board. If this was a company, it's the board in the province. Then if there is an AGM in that company, the person who has the highest authority, the board or the PEC, is clearly the one that is going to invite you, that's going to give you tea and coffee and all that, because it's their functionality. And if it's here, if there's a meeting here in this court, the person who's at the top of it is the deputy judge president or the judge president, who oversees the whole thing. He can't just hear that there's a conference here on the first floor. So even from that, it can be implied. Yes, it can be taken from the part that your ladyship has taken.
No, let me give you an example.
Yeah.
Now that you've talked about the JP, there could be, yes, the JP is the head, but then there's a meeting of the heads of divisions here who would be meeting in between the meeting of the provincial heads of courts. And those, from what I'm reading here, they would be the ones who are now, in terms of Rule 17, be the one who have been appointed
Absolutely.
to deal with the issues of the conference.
Yes.
It's not the PEC.
No, my lady. It's like saying the event organizers are now running the show. No.
No, but they've been appointed by some entity with power. It says here, provincial conference, subject to decisions of the national conference, a national general council, and the overall guidance of the NEC. The provincial conference shall be the highest organ of the ANC in each province.
Yes.
The provincial conference shall, and it tells you what it can do, and amongst which 17.2.2.5 is to appoint a conference preparatory committee which shall circulate conference.
Thank you. Okay, that's
your
good.
complaint, Mr. Mpofu, is that there's this illegitimate structure that is now conducting a PEC, a conference,
No, my
which
lady.
is and the simple answers that I'm giving from the Constitution.
Yes. My lady,
But
again,
it's a merit issue.
Yes, it's a
Mr.
merit
Mukari
issue.
is entitled to
To deal
give
with it.
further guidance if I'm out of line.
Yes, of course.
Yes.
To interpret the Constitution as he wants.
But
yes.
I'm saying what you are telling me. You are complaining about this PEC that's unlawful, that is now running this show. And I'm saying, from what I'm reading, it's not the PEC. Can we move on to other issues?
Can I please just address your leadership on this issue? Really, this is
that's the crux.
This is the basic part of this case.
But you know what? Your papers, because when I read them, as you clarify them about why you are here, it makes maybe because you drafted in the middle of the night.
Well, we all did.
In the papers, the complaint is about the decisions that have been taken that must be set aside, that must be this PEC is still going to take unlawful decisions. But if the crisp issue is that there's this PEC that's unlawful because its term of office has expired, that has now been given a mandate to conduct or run this conference that's underway. Then I think we can move. We would be done by now.
Yes.
Any other submission?
Yes.
We're still on agency.
Yes. I just want to make one final submission, if I may, Madam.
Yes.
Which makes the point even clearer. When the Constitution of the ANC says, and it doesn't matter whether you're talking about the NEC or the PEC or whichever structure, when it says that between conferences, the highest decision-making structure in the country, for example, is the NEC, right?
Yes.
Now, that means that all it means, to put it simplistically, you can't be calling a conference every day. You have to make a decision. So the NEC is then given 5 years to run the show.
Yes.
Similarly, in a province, as 19.1 says, the highest decision-making structure in the province is the PEC. Why? Because you cannot call a provincial conference every time you have to buy this or this or do that.
Yes.
So the PEC is actually the ANC.
Yes.
Now, if you accept that as a premise, then we go to where your ladyship was reading at paragraph 17.
Yes.
Where it says what I call the event organizing structure would be appointed by the conference. But since we know that the conference can't be called every week, the people who actually do that is the PEC. So there are two things that can run the show, quote unquote, in Limpopo. It's the conference or it's the PEC. And the PEC runs the show by virtue of 19.1, simply because you cannot be calling a conference every time you have to take a decision. So that's why the Constitution says between conferences, the highest authority that runs the show in this place, in this particular place, whether it's the Free State or whatever, is the PEC. Including the appointment of that preparatory committee and what have you.
Let me ask, because I will hear what Mr. Mukari says, what this decision to extend the mandate means, because my understanding is the conference by 18, everything had already been prepared. And it can't be that this structure is now, the mandate that it's given is to organize the conference in the sense of it running the conference, which is why the ANC is saying, no, this is not the conference of the PEC.
It's the conference of branches.
Conference of branches. It has already been organized. The PEC members are participants, so we can look at them in their roles as participants, but not as
let me tell
people who are actually
running the conference.
Running. I don't know what the word runs.
Okay.
In this context would mean.
Yes. No.
But to say they organized, they made decisions, they because it does not even look like it's to say they are being, whatever they have done to organize the conference is being ratified. It says we are extending your mandate. What does that mean? That would make you to run to court.
All right. Let me just tell you what the PEC itself says.
Yes, what page is that?
Page typed 9.
Remember, we I've read their answering affidavit this morning. And
yes, I appreciate
the respondents, when a respondent bring themselves to the slaughterhouse,
yes,
where the applicant has not made a case, then they come and be giving more meat to the matter. But we are talking about your version. You can tell me what they're saying.
Yes. Well, my lady, that's why I'm saying the showstopper in all this must be, let's forget about what we are saying. Let's hear what they are saying.
What are they saying?
At paragraph 9.
Page?
I'm sorry, page 9, paragraph 38.
Of your...
It covers everything I've just said now, actually, more succinctly. It says, on the 19th of February 2018, the PEC held a meeting.
But this is your affidavit?
No. I'm sorry, it's bundle B, my lady.
Okay.
Bundle B, page 9.
Bundle B, page 9. It's
their answer.
Yes, the affidavit of Elias
Mahashul.
Yes.
Yeah, that's their affidavit. Yeah. Okay. It says, on the 19th of February, it can't be clearer than this, the PEC held a meeting. Let's just stop there. Remember, at that stage, that PEC was dysfunctional and invalid. Just flag that. Let's flag that. And it says, the meeting reaffirmed the cut-off date for the purposes of membership audit to be the 30th November 2017, which has been delayed. The PEC also resolved that due to the delayed membership, the provincial conference should be held on the 13th to 15th of April 2018. Further, at this meeting, the Provincial Preparatory Committee, that's the event organizer, was established by who? The PEC, to oversee all the logistical arrangements relative to the conference. The following members were elected, not CRB, blah, blah, blah. What is the point there?
He will explain.
No. It's the clearest thing that ever comes of that. If anybody wants to say...
No, I'm saying from what I have read, between what I've read in the Constitution and what Elias is saying, Mr. Mukaru will explain.
Well, he can't unexplain something said under oath.
Yes.
Elias Mahashule, who is the Secretary General of the organization, says that the PEC is running the show. He says that they collected the preparatory committee, they decided that the thing should be held on such and such a date, they decide which branches should come, and as we know from the Constitution, they even do the invitations. I don't know what other show really.
Does it say anything about this, because this is the conference of 13-15 April.
But it was obviously postponed. But the point I'm simply making is that whether it's this conference or another one held 10 years ago, it's a conference of the province of the ANC can only be done in this way. There's no other way. He's just explaining how, for example, the preparatory committee comes into existence. That it is appointed by the PEC. Even the preparatory committee itself was established by the PEC. And in case there's any doubt, let's hear what the Constitutional Court has to say about this point.
Just a minute.
Oh, I'm sorry, my lady.
Just a minute.
Yes,
Let me record this.
As the court, please.
If the preparatory committee is appointed by the provincial conference, so I think accepting the appointment themselves.
Yes, you say Concord? Same
Concord,
case?
page
The
37.
same Ramakatsa.
Ramakatsa, my lady.
Yes.
Paragraph 77.
Yes.
Yes. Remember, before I read, let me just develop this point.
Yes.
Remember, what we're saying really is this, my lady, that if let's assume again that we say the term has expired and so on. The only issue really we are now examining is to what extent does the taint of illegality that we all know is around the PEC taint the whole conference. That's really the issue that we are examining. Now, this is what
yes, which is why you would want the whole conference to be
absolutely, yes,
interdicted.
that's why I'm saying.
If they
taint, if they don't taint, they don't taint. If they do, they do. Yeah,
yes.
That's all. So this is where and we say they taint because they are the ones who are running the thing.
Yes.
As demonstrated even by Mr. Makhashu. But paragraph 77 says this is where Musaneke, DCJ, and Chafta J said in the image for the majority judgment. Whenever a conference is planned, right? Whether it is a regional or a provincial conference, that's the PEC, nobody else, the PEC must determine a cut-off date for purposes of conducting an audit process. On that date, once that date passes, the National Audit Committee must verify paid-up members of each branch intending to send delegates. It must also determine if branches are in good standing. On completion of the audit for a region, the team must submit a copy for the preliminary report to the relevant provincial secretary. In this case, we can say to the illegitimate provincial secretary. Okay? So that's taint number 2. And then it says, the National Audit Team should respond to every query when necessary and make corrections of a preliminary report. That's fine. Then here's the part. If the branch is still not satisfied, it may appeal presumably to the REC, the PEC, another taint. So again, you would have been appealing. The branches that were being sanctioned were inter alia being sanctioned by the illegitimate PEC, or to the Secretary General of the ANC, who is the final arbiter. That paragraph covers actually everything we've discussed this morning, which is that the final arbiter is the NEC, but and that's in the context of exhausting remedies. But in the process of qualifying, let me call it that, to be at the conference, the PEC plays the central role. Whether you read the first sentence or the last sentence of that paragraph, it's clear that the PEC, as Musaneke says, must determine the goings on there. And really that's all the applicants are saying. They're saying, look, if this thing is fundamentally flawed and illegal and it could be organized by a Stockfell for all we care, because this PEC is not part of the legitimate structures of the NEC, then let's assume your leadership says it must continue. That it won't make any sense, because it's going to continue again under the auspices of an illegitimate structure. It continues on the wrong assumption that the expiry of the term of the PEC is going to be tomorrow or on Sunday when the new PEC is elected. But that's wrong. We know factually, and the ANC does not put any defense against that. Actually, they concede the point, both in the letters and in the affidavit, that this term of this PEC expired on the 15th of February. So, I mean, I can also call something at my house and call it a provincial conference. Nobody will care if I do that. The point of the matter is that a real provincial conference must be called by and run by a legitimate structure. If that is not so, that's the end. That is why we only came here on one specific issue. And we said, court, forget about the Peter Mokaba and what have you. But the point of the matter is that right now the house is burning. There is a conference taking place which is so tainted by illegality that literally everybody who's there has been invited by these bogus people. Every single person, including the media. Anyone who is there by virtue of these things. We now know that even the preparatory committee of that conference was established by them.
But
after the expiry.
For the one that was postponed, we don't know for this one, unless if you want to say failure to have explained how this one was organized. We must just revert to what they've put on paper. But
no, I'm sorry, with the greatest respect. Surely, if Mr. Makashule, who is the administrative head of the organization, tells this court that a preparatory committee is established by the PEC or was established by the PEC, where is the court going to say
no,
that was an exception? It was just an exception.
What I'm saying is, this paragraph talks about a particular preparatory committee. It doesn't say, let's go back to it, that's paragraph 40.
Page 9.
Paragraph 38. What I'm saying is, let's read what he is saying. He is not saying this is how all PECs are organized. He says, paragraph, it starts at, the heading says pertinent background. 37, he says the last one was held on 15 February 2014. 38, where you are at, he says on 19 February, the PEC held a meeting. And in that meeting, amongst other things that he's saying, he says they further at this meeting, the Provincial Preparatory Committee was established to oversee all the logistical arrangements relative to the conference. Which conference? The conference of 13 to 15 April 2018. What you want me to do is to read this paragraph as him explaining the procedure. And what I'm saying is, maybe further down in this paragraph, in this affidavit, he must have said something about how this particular conference was arranged. What you want to rely on is the arrangements or preparations for the conference that was to be held on 13 to 15 April 2018.
Okay. No, that's not what I'm asking.
No, I can't read what's not in the affidavit. Yes. What you want me to do is to say this is what this affidavit says. This affidavit says what it says.
I said, my lady, with the greatest respect, I didn't say what your ladyship is saying I'm asking her to do. I said, read 3 things.
Yes.
This paragraph?
Yes.
1. Read the constitution of the ANC, which says that a preparatory committee is established by the conference. And I said the conference obviously then delegates that function between conferences to the PEC because it's the highest body. 1, that's number 2. Then I said, if that's not enough, read Musaneke and Jafta J's dictum at paragraph 77 of the Grabakata case. I did not say just take this and assume. If you read those three things together, you read this paragraph as to how it was done. There's no suggestion here that this was some exceptional circumstance. But I'm happy to say that's not enough. Then you go to the Constitution. The Constitution tells you how such a preparatory committee would be established. That it's either the conference or the PEC, because those are the only two bodies that have the overall authority. It's either a conference or the PEC. It can't be anybody else who establishes the preparatory committee. Put that in your mind, and then the third point, then read what the Constitutional Court says. Any conference of the ANC, whether it's regional or provincial.
I agree with you with regard to what Elias says in his affidavit, paragraph 38.
Correct.
I have noted what Museneke and Jafta say.
Yes.
What I don't agree with is you wanting me to read clause 17 of the Constitution that, let's just go to it to say that's the PEC. It's not the PEC.
No.
Let's go to it.
It's not the PEC, my lady. We don't even have to go there. I've
Yes,
said
so
the PEC is the substitute between conferences of the conference. It's the only other, just as the NEC is the substitute of the national conference, which gets called every 5 years. The PEC, according to 19.1, is the substitute of the.
I have no qualms with that.
Yes. So
what I'm saying is we are talking about who organizes or prepares.
Who appoints the preparatory committee.
And it says here, clause 17.2, it starts with a provincial conference, shall, 17.2.5, appoint a conference preparatory committee.
Exactly.
Yes, but what you are saying, I must read this with 19.1 to say it's actually the PEC.
Of course, and because otherwise you would have to call a conference every time you have to call to establish a preparatory.
But we don't know. That may be an issue in dispute. We'll hear how it progresses.
All right. Okay. Anyway, then at that point, then that's when Mr. Mahashule's ipsi sima verba becomes important as to actually how it's done. But I can't, my lady, take that point any further than the as I said, those three instruments read together make it patently clear, and there's no argument whatsoever in the answering affidavit that of exceptionalism that it's unimaginable as to how else a preparatory committee can be formed. It can either be done by a conference or a PEC. There's no other way of doing it.
Yeah, but if there's something in writing, we take what's in writing. Let's move to. So you're saying, you haven't addressed on the why you would not get substantial redress, but I just want to understand you on agency. You are saying I must take into account the constitutional imperatives that this kind of matters. It's not just if
between these parties.
Yeah. So it's the agency is founded on the Constitution. That's what you say.
Yes, on the devastating impact.
Yes,
let's put it like that.
When I look at agency, that's what I must look at.
That's correct, ma'am.
And then, but now let's go to the second leg of agency. Why you think you will not get substantial redress?
In due course, yeah.
In due course.
It's not that simple then, my lady. I won't even spend 2 minutes on that. Again, if we accept that the trigger of this matter was on the 18th, as we have argued, then that question answers itself. Between the 18th And what's the date? Today, 23rd.
Yes.
What could the applicants have done?
But
and we have said
what's the redress we are looking at?
Yes. Remember.
What's the redress? What's the remedy?
Yes. The remedy is in the we went through it in the notice of motion. For now, the remedy is the continuation of an illegality. So so we're saying that illegality, as I've said earlier, sprang up from a litigious point of view, at least on Monday, and between Monday and now, to anyone who says they could have had redress in due course will be making a joke, because in due course means that that application could be heard maybe in October or something, if you are lucky. For a conference that's happening on Monday, it's happening on Saturday. I mean, it just answers itself. So the important thing is just to accept that the trigger was on Monday and the conference was on Saturday. And the second meeting of trying to resolve this internally was on Thursday. That's all really we need to know. Then, as I say, if given those circumstances, you then say, no, what you actually should have done is to go to Rule 6 and give them 15 days to answer, and you get 10 days to reply. I mean, it answers itself. So the only way, either you just accept your fate and live with it, but if you're going to go to a court of law, you could only come by way of urgency.
But maybe we started at the tail end. Let's start here. The injury. What is the injury? Because when you identify the injury or the harm, is then that you can say
100%.
I have the apprehension that I'll suffer this harm.
Yes.
It's irreparable, but then again you have an alternative remedy. But then you will then argue, but even if I have, by the time I get redress, it will actually be futile.
Yes.
I would have. So let's start there. What's the injury?
Okay.
What's the harm?
The harm, we started with it, is the harm to the applicants of having an illegitimate organization of their choice. The rights that we're talking about here come from Section 19 of the Constitution. The Section 19 of the Constitution says each of us as South Africans have a right to be a member of a political party of our choice. And then the Constitutional Court says that right is enjoyed by joining a political party. When you join a political party, it says the constitution of that party becomes the contract between you and the party. And therefore, that's how one must look at the nature of the harm. So if nobody will join a political party if this kind of thing is just allowed to happen, it would be a threat to our democracy. Remember, our democracy is founded on a multi-party democracy. Let's assume all South Africans decided they're not going to join political parties because they are run like this. This democracy would collapse. So it's important for the court to protect and preserve the institution whereby we join parties, they give us a constitution, but then they must abide by the constitution. That's why Yakub says a member of a party is entitled to exact compliance, not even substantial compliance. Paragraph 16 of the Rabakatsa case. A member of a party is entitled to exact compliance, because if we tamper with that, then we're killing the entire democracy, as I've said. Now, how does that relate to this particular case? The harm that eventuated was that, right, the contract that we're talking about also has some shackles. It says, like, if I was a South African and the ANC takes my car or whatever, I can take them to court at any time I like. But if you're a member of the ANC, you have a different, your rights are limited by yourself. That's why it's called a voluntary association, because nobody forced you to go and join. So you limit your rights. How do you limit your rights? You limit your rights because now you have to first exhaust internal remedies. Unlike Mr. Joe Soap in the street, you would have to exhaust internal remedies before you could approach a court. So the harm only arises really once you have done that, and that's what these applicants are saying. They're saying the harm in respect to this conference arose when our beloved NEC, to whom we had put all this hope that they're going to resolve this thing, failed us and actually endorsed the non-existent PEC. So it arose on Monday. That's why I'm saying once you accept that, then the rest really we don't have to go through it.
So if I understand you correctly, I must also have some debriefing in my head, because what I've read relates to a PEC that expired, its term expired.
Yes.
It made decisions that are lawful. It may continue to make such decisions, but I must forget about all.
No, your ladyship will, with the greatest respect, have to disabuse your ladyship's mind.
No, now
of that.
What now the harm that in that from what's written here, my thinking was, here is a PEC that was its term expired, and you know when they continue to make decisions, they can't even be held accountable, because now they say we were not even.
Yes.
Why didn't you see? Why didn't you go and challenge? So that's what I thought.
Yes. No.
But then now they are bringing it closer to themselves. You see, that's where now we're going to have a debate about the people of there's this challenge that some of us can't pronounce the word
Limpopo. Yes, it's a big problem. Yeah, it's actually Limpopo, but most people say Limpopo.
Yes. So now it's the harm now is the applicants would not want to be party to or join a political party that does not
respect its own
constitution. So it's them now.
Yes.
It's about them
it's
now.
About them.
It's no longer about the entire
general. Yes. No, that's true. That's exactly what the Constitutional Court says. Because remember, to open the door, you must be a member of the ANC. Because you can't just say, oh, the ANC is just holding a conference and I'm a member, I'm a person in Limpopo. To come here, although the court, according to the Constitutional Court, must take into account the impact of this, particularly when it comes to agencies. Your ladyship has already summarized that correctly. But ultimately, the court must say, what harm, as this court is saying, is you, Mr. Nung, and Mr. So-and-so and Mr. So, qua members of the ANC, not as citizens of the country, what are you suffering? And they are saying, very plainly, as it says, I think Yakub says it, it would mean that Mr. Nung is going to be governed for the next 4 years by an unlawful gang.
But he has an option to opt out. I thought you are talking about them as citizens of this province that must be led by, because that's the case that was made, that this PEC has the powers to take decisions for the entire province. But if it's about them as individuals, the constitutional right, then they can, why don't they opt out?
No, my lady, that's a huge fundamental mistake. That's exactly what the law says we should do. Because if you did that,
but is that not what contractual is all about?
No, that's why the Maramakata says this is not. It's a unique contract because it has constitutional implications. Assume what your ladyship is saying. That's why I've just said. Everybody just says, reads about this case and they hear that this is what happens. Actually, people can wake up and do a conference. And all the parties do the same thing. and
but you know,
and then they opt out. They all opt out.
One of your applicants is said to have even participated.
Yeah, but
in a, you know, which is why you don't want to go to the history, their knowledge, because they are not bringing it on affidavit. That since they became aware that this PEC is illegal or unlawful, they chose not to keep quiet. And you say, I mustn't go there, I must just go to what happened on Monday.
Yes.
So I'm saying on Monday, this decision, how does it affect them as individuals? Because now you have moved away from the
no, I'm sorry. I've not moved away from anything.
The province to them to say they have a right to join a political party that is not tainted by illegality.
Yes, no, I'm sorry, my lady.
Yes.
If I gave you that impression, I was wrong.
Okay.
There is no way that this court or anybody can isolate these rights and say, it's the here now, it's this one, it's this one. You are a member of a political party in a constitutional democracy called South Africa. You are also a citizen of Limpopo. You are also you are also whatever else you are, and you are also a voter and a person who might actually end up being the president of this country. So even your Section 19(3) rights for you to become a president or a minister or whatever can only be. That's why this case says political parties are the conduit through which we exercise our democratic rights.
Yes, I understand that, but then the ANC says the reason we are even having these conferences is to deal with those lapses in so how is it ever going to be rectified if there's no conference?
Then, Your Ladyship, in fact, my lady, if I may, the answer to that one, Your Ladyship, will find in can I just hand up the notes, my lady, there's just a quotation. We need to get to the answer.
No, I was still recording what the harm is, that the right to join a political party, no one would want to join a political party that doesn't abide by its constitution. And by this, we excluding the decisions, but the issue of a PEC that overstayed.
Yes.
So it's not about their decisions.
No, yes, and then
so then, if you identify this harm, then it's what redress are you seeking?
Okay, I'll come to that, my lord. Can I just start with this? I just want to answer the question.
Can I read what's this?
It's our heads, my lord.
I have a copy. Is it another one?
Or was it handed up earlier? I'm sorry.
Yeah, you left.
Oh,
you gave it to me in chambers.
Yes, of course.
I can donate it.
Yes,
so you
donate
can.
It to my learned friends, Julian. If Your Ladyship just goes, because I want to answer the questions in sequence. Your Ladyship has asked me two questions.
Yes.
The first one was about the harm that comes from the fact that this is a dysfunctional PEC.
PEC, yes.
The law on that, my lady, is very crystal clear. If Your Ladyship goes to page 20, paragraph 20 of our
heads.
Yes, of our heads.
So it's the paragraph you read in any event. Nay is
it's a misprint. It should say in any event. Yeah. No, if Your Ladyship can just bear with me and let's start at paragraph 18.
Yes.
We say once the term of office has lapsed, we were through that. The Constitutional Court has explained the implications. In paragraph 84, the Constitutional Court stated, that is of Ramakati, stated in explicit terms that the Provincial Conference elects the PEC, which holds office for 4 years. In the specific case of Ramakatsa judgment, the Constitutional Court also stated as follows, quote, the 4-year term of the PEC was due to expire during the course of 2012. This meant that an elective Provincial Conference had to be convened. There is therefore no scope for ambiguity. The term has lapsed and the Provincial Conference had to be held. No power existed to do otherwise. And here's the important part. In any event, the authorities are clear on this point. In the judgment of Wessels and Smith versus Vanugo, which there's the only judgment I brought here in the book. Wessels versus Vanugo, it says the following. I quote, an invalidly constituted board, improperly convened and without a quorum, cannot take a valid decision and nothing exists to ratify. The critical point is that the decision maker was incompetent to make the decision. And here's the next page. As elucidated in that judgment, what is ab initio null and void remains so and cannot be fanned into life by the breath of ratification. That judgment remains good law and was cited in Matipa and so on. What does that say? Yeah. All it says is that you cannot, once the corpse is dead, it's dead. You can't do a Lazarus on it and breathe life into the NEC, or rather the PEC that is gone. So it does not matter what the NEC says in March or April and so on. It's dead. You can't breathe life into it. So to say to come now is a bit of a joke and say, no, sometime in June or May, we actually extend it. Extend what? You can't extend the life of that which died on the 15th of February. So that point is the easiest part of the case, which is that and in the Pillay case that we also cite in the heads, it's made very clear. That was the case of Godongwana. Godongwana and others versus Honorable Mr. Justice Pillay. Your Ladyship will find that case at page 4, paragraph 9 of our heads. Yes. Where the term had come to an end of office of a commission, and the court said, in terms of paragraph 3, the terms of reference of the commission was to endure for a fixed period of 6 months. Here it's 4 months. It is implicit, therefore, that both the inquiry and report would have to be completed within the stipulated period, or such extended period, any further proclamation decreed. Now it says on the next page, if the further extension was legally valid, and about which I have grave reservations, in this case it's more than grave reservations, then the commission ceased to exist beyond that date, absent a proclamation to that effect. None has been shown to exist, and so on and so on. So there's nowhere, you can look through these papers, there's nowhere where the NEC says that before the proverbial death occurred, we extended this PEC. And after once that is accepted, then it's inextensible, so quite frankly.
I didn't get the part, or you still going there, why you say...
May I hand up with the Kotongwana judgment?
Yes.
Yes, I'm sorry, I'm interrupted, Your Ladyship.
Is it in your head of argument?
Which part, my lady?
The Godongwan.
Godongwan, yes, it's on page 4, my lady, of our heads.
Okay.
Page 4, but I've just ended up a copy. It's Godongwan and others versus Honorable Mr. Justice Pillay.
In relation to?
To the expiry.
Okay. In relation to what the injury or the harm.
Yes. Yes.
Why can't they be heard in a month in the ordinary motion court?
Because, my lady, as we have explained, if that happens, then by November or December or January or whenever the matter might be set down, but by then, it would have meant that this court, despite a citizen coming to court to ask for relief, has actually allowed an unlawful, or rather the political harm in terms of Section 19 to continue for another 6 months. On what basis, my lady, can that be allowed to occur with all the grave and some of them irreversible, I think we use that word, consequences of that, in the sense that you're going to, as the Concord says, you're going to then have these people electing the so-called list conferences for the elections, determining how million, I don't know how many members they have in Limpopo, but let's say thousands. How thousands of people enjoy their Section 19 rights. All along, we know that they are unlawful, but we're just simply saying, no, they must just wait until the court can set the matter down in January next year, or even after the elections.
But you know, which is why I say I was thinking it's about unlawful decisions that they may continue to make, and which they've made since February. They could have even sold the province.
Yes.
And you are not interested in that. You're only interested in the political participation of the members.
No.
Or it's inclusive. That if they have this kind of they have been allowed to overstay their term. What's the complaint? That another concession will be made, that they will be allowed to stay another term, or the decisions? I thought it's about the decisions that may be unlawful because they were unlawful, and you have to review each one of them, which is a point that I've seen the respondent making, that because you say they've been making decisions, they continued beyond February. They have had dealings, obviously, with the regions, with the branches, making the members they deploy to government, and all the consequent decisions. Are we not going to review those? Are we just going to leave them and say the conference is interdicted, we happy?
Yes, my lady, that was the reasoning of, I think, Froneman J. In Lamakati, on which 10 other judges said, no, you can't, because Froneman J. said, if said exactly what your ladyship is saying. I'll just find it now. I think it's paragraph 14. If you let it. Yes.
But what happens to their decisions since February?
If I can just say, this is what the court rejected.
Yes. Paragraph
44.
Yes.
He says that if, although it's understandable that would have been served practical purposes better had the disputes been decided before the national conference was held, it would not have been the end of the road legally if this were not done. If it transpired that the election of provincial delegates tainted the national conference, it would have remained open to approach a court to declare the subsequent results invalid. For these reasons, I consider that leave to appeal should not have been granted. The reason why the Constitutional Court rejected this approach was exactly because the Constitutional Court said, no, you can't reason it like that. You can't say let the illegality continue. That's why the Constitutional Court had my case on an urgent basis in November of 2012. Because it said the conference, it was even better than this current situation. The conference is coming on the 14th or 15th of December 2012. Here, the conference is happening now as I'm standing here. So it said you can't then say the remedies must be obtained after the conference has happened. You have to nullify it and declare it as non-existent, and they must all go back to...
Maybe you didn't understand me. I'm asking, my question is, are you not interested in the decisions they have taken? You interdict the conference, is that the end of the matter?
Yes, my lady, yes. For the purposes of this application, all that will happen is the following. Let's just postulate. The court will tell what we all know.
There's a difference. If we were looking at, you were interdicting the conference for some other reasons, because maybe the peace for, and we are able to say definitely, with definite certainty that it's a PEC that has not misbehaved, which we don't know. But even if they did not deliberately misbehave, the fact that they were unlawful on itself, it places their decisions in jeopardy. But they have to be challenged, each one of them.
Yes.
So you say you are not going that route. You just want the conference to be interdicted, and whatever happens to the decisions they have made since February, when they were they became unlawful, that it's not something that the applicants are interested in.
No, my lady, yes. You see, in the case of Taba in the Constitutional Court, and the case of Makanya in the SCA, that was made very clear that a litigant, you can't say it was in the context of this thing about whether you go to the Labour Court or the High Court and so on. And Nugent in the SCA and Langa in the Court said a litigant might have 5 causes,
100 remedies, and he chooses one.
Yes,
and today you have chosen the political affiliation one.
Yes.
And the question is that urgent?
Yes, that's correct. Now, thank you. So now, if we accept that these particular litigants have chosen to enforce, they might have 100 other rights.
Yes.
To enforce their right to a conference that is lawfully run. Nothing more than that.
Yes.
All they are saying to your ladyship is, please deliver to us a lawful conference, and do not endorse the unlawful one. That's all, in simple language.
Okay.
Then
I hear you.
Yes.
Let's move on.
Okay.
You've been saying
can I just finish this point?
3 hours. I can
I know,
move on
it always happens like this.
Yes.
The simple point I'm making, my lady, and that's why I make this example.
So are you saying for the relief they are seeking, there's no
other way?
There's no redress
in due course?
In due course.
Definitely not. 100%.
I don't know. Well, but because the papers I was reading
okay, my lady.
are different from what you are saying.
Let's break it down. Let's break it down. What is the redress that they are looking for? Is to stop
the redress
the conference.
Looking for is to say we have a right to participate in.
No, that's the right.
Yes.
The redress is to stop the conference.
Yes.
The right is something else.
No, I mean
they are right.
Yes, they are right.
They are riding on that right.
Is to belong to this political party that's not tainted by illegality or unlawfulness. The unlawfulness arises from the fact that this PEC overstayed its welcome, and then the NEC, instead of dealing with the matter, just endorsed their unlawfulness and mandated them to run this conference.
Yes. Now, let's call that the vehicle, the car, yes. the horse. So that's the cluster of rights that your ladyship has just summarized correctly, on which they are riding. For what? For the redress. That's not the redress. That's the vehicle. The redress is something else. The redress is not the car, it's the destination. The redress is having all those rights about citizen and what have you, and where do they want to go? They want to go to the stopping of the conference that is taking place. That's the redress.
No,
Can that redress ever be achieved in due course?
Let's move on to the next. Now
Yes.
we have these applicants who can't get a meaningful redress
In due course.
tomorrow or next week.
Honestly.
Then the other requirements of the final interdict then kick in. They must demonstrate their right.
Are we on the merits now?
No, I mean, if you say it's you said you're going to argue everything. It's someone who says I have no redress, this is my all, then it means I'm entitled to it. I have a right to it.
Yeah.
I have a right to it.
Correct.
Yes.
The ladyship is correct. You see now, I'll use the same analogy. When it comes to the clear right, which is what we have to establish.
Yes, you want a final interdict.
Yes. Well, when it comes to the clear right, then it's what I have in my analogy called the car, the vehicle. I would then have, let's now put aside the thing of redress. For the clear right, I have to convince your ladyship that these applicants are possessors of enforceable rights in this court which accrue to them. We have said already that those rights arise from at least two sources. And your ladyship is bound by the decision of Ramakatsa on that point. So your ladyship does not even have to make a decision. Ramakatsa says that right stems from two sources. One is the Constitution, which we have discussed, Section 19. The second one is the common law, which is the contractual right with all the qualifications. That is a sui generis type of contractual right. So there's no question. All these cases, even Dube, have we cited Dube? The case that happened in KZN, and the other one we've done almost 10 or 15 of these cases. All of them depend on the same right, which is the Section 19(1) right, read with Section 19(3) of the Constitution of the country, as well as the common law right, which arises from what we call the what are they called now? The Jockey cases. The Jockey cases, the Jockey Club cases, which Musanega refers to, simply say that when you are a member of a voluntary association, then you acquire contractual rights just as a member of that voluntary association. So the rights, the list of the problem in this case is the rights. The rights are multiple. In that case, actually, we even asserted a third right, but the court said it did not decide on it. It was whether there was another right arising from Paja, because a political party is an important institution, blah, blah, blah. But the court did not make a decision on that. It left that question open. But as to the source of the other two rights, there can be no doubt whatsoever. In fact, Mr. Mukari, I've had these cases against him many times. He's not going to argue that there's no right under Section 19 of the Constitution. So, but you never know. If I'm wrong, I'll deal with it in reply. But he knows the rights. In fact, that's why they didn't even take that point in their in their answer.
I'm reading.
Where is your leadership?
I still want to understand how you and the respondents came here, I think I'm missing an annex from FA7.
From FA7 onwards?
No, I have I have 7A. I'm looking at A. FA8.
FA8, that would be page 100.
Oh, okay. So,
page 100 of bundle A.
FA9. I want us to wrap up the basics because I don't want to be left with questions here.
Yes, my lady.
I'm looking for the decision that you say brought you here.
Oh, well, that you can even find in the founding.
This should be FA, according to your affidavit, it should be FA9.
That's correct. Yes, yes, my learned friends have whispered that it's often. That would be obviously after page 100.
And so I'm reading that with it's page 107. I'm reading that with paragraph 39.6 of the founding papers.
That's correct.
That says on 18 June 2018, a special National Executive Committee meeting was convened. One of the items was whether to allow the provincial conference in Limpopo to continue. The decision, no, I started,
in fact, where's your ladyship reading? Paginated page?
Paginated page 22, the typed pages.
Oh.
Yeah, yes. This was one of the items to be discussed at the meeting was whether to allow the provincial conference in Limpopo to continue. This was on the basis of complaints lodged by branch members. The decision, I'm advised, was taken that such conference would indeed go ahead, and there was an attorney briefed. He wrote on 19 June, then a copy of the letter. So the letter that you say is the reason you are here is FA9.
That's FA9.
FA9, yes.
That's correct.
Paragraph 39.7.
39. Yes, read with 39.7.
Yes, which says the letter records the following with regard to the allegations that the term of office of the Provincial Executive Committee has expired and the term of the RTT in Pitamkaba region has expired. I say that it's precisely for this reason that regional and elective conferences are being convened to refresh the mandate of these structures.
In fact, yes, my lady, that part is a verbatim quotation of what is at page 109.
The letter?
Yes, the letter at 109 makes it very clear. Actually, that helps me for two reasons. It also deals with one of the earlier difficulties your ladyship had as to whether they were aware of this complaint about the PEC. It says, with regard to the allegations that the term of the office of the PEC had expired, and the term of the office of the RTT, you can ignore that part. I state that it is precisely for this reason that the Regional Elective Conference was being convened to refresh the mandate of these structures. Now, what they are saying there is that because these things had expired, they were capable of breathing life back into them, which we have addressed.
Yes. Now, okay. The letter also has an answer to what we were debating about.
Yes, correct.
The paragraphs in page 108.
Yes, I'm there, madam.
It's also important to point out that outset that the Provincial Elective Conference of the province due to take place between 22 and 24 is a conference of branches convened at the request and directive of the NEC. And for this purpose, the NEC deployed a team of its members to exercise jurisdiction over the conference and adjudicate any dispute that may arise. The deployees have been working in the province for the past few months in preparation for this conference. So you are saying the basis of the relief you are seeking in paragraph 3 4 and 5 is because of the decision to extend the mandate of the PEC.
No, yes, it stems from that, but it's the decision to have that mandate extended to such an extent that the illegitimate PEC is now running a conference, which we have debated.
Yeah, so we have debated that.
Yes,
when I read the letter FA9, it says there are individuals that are running the conference.
Yeah, no, it says that thing about the conference of branches.
And the NEC members who have been organizing. So, but
that's the
it depends on the findings I make.
Absolutely.
Yes.
The point we are making there, my lady, is that your ladyship, with the greatest respect, cannot make a finding that flies against what the Constitution says. It doesn't matter what they say. They can say it's a conference of branches, whatever that means. But the point of the matter is that the Constitution of the ANC, the Mahashule, and Rabakata make it clear, actually, what the role, the pivotal role of a PEC is.
Between Mahashule and the Constitution, who do I choose?
All.
When it suits you.
Yes.
What if it doesn't know the Constitution?
No, because, they accept this, my lady. Actually, if you have to choose. If you have to choose, you obviously would have to choose the Constitution because Mahashule is an interested party. He is subjective in this particular. Remember, it says that it's his decision that we are here to attack. That's why we've cited him on the page. So, but the Constitution, when it's drafted, nobody knows that one day it will be Mpofu or this one or that one. When you draft a constitution like the Constitution of the country, you can't say a particular minister now wants this. No. The Constitution was drafted for the general situation, let alone the Constitutional Court of this country, which is the highest thing, that says this is a role that a PEC should always play. So the letters of Mr. Naidu and...
we are done with the redress, and you've heard my comments that from what I was reading, the issue was that these people are likely to continue to, their illegality means that their decisions that they've been making since February will continue, and that can be addressed at a later stage. But if you say that's not
by other people who have an interest,
if you say that's not the issue, then we'll hear what Mr. Mukari
has to say.
Says is the issue that he thinks is here to meet,
to deal with. Yes. No, my lady, I just want to close that issue by saying that your ladyship must again take from your ladyship's mind anything to do with decisions of the PEC. It's not about that. What we're here about is that the PEC is, objectively speaking, non-existent. Whether they take good decisions, bad decisions, great decisions, it's irrelevant. The point is that there is no PEC as we're standing here, and yet some people who purport to be the PEC are giving a report of the secretary, what secretary? And another one is a report of the national chair. There's no such people. They don't exist, legally speaking.
Well, if there was no conference, it will be easy to deal with that, because the question would be, is there a PEC? But then you want to link that to the conference to say the conference is being run by a PEC, and then the ANC says, no, hold on, this is not, the PEC is also a participant in this conference. It's not the one running the conference.
No, the two are not mutually exclusive. The mere fact that members of the National Executive Committee, for example, run the conference in Nazareth, and the fact that they are also participants, voting participants, those two things don't clash. Actually, that's how it works. So they would both be running the conference in Nazareth, and they will also be participants like anybody else. And when it comes to voting for the president or whatever, then they're like everyone else. So the fact that they are running the conference has got absolutely nothing to do with the fact that they are. In other words, we're attacking two things. For the first leg, and your ladyship demarcated this correctly. For the first part of their participation, then we say, okay, well, they themselves must be taken out. But for the second part, which is
the whole conference,
yes, running the whole thing, then obviously that particular taint is not personalized. You can't personalize it. That taints everything. Every time they say, we're now going to have a break for 2 hours, who are you? People should just say, why must we want the break for 10 hours because you don't exist? So everything.
But you know, my difficulty, I will also take it up with Mr. Mukari, is if we say the issue is the mandate to extend, the decision to extend their mandate, and that was only done on 18, it's how many days now?
It's four.
And it simply extend their mandates as PEC. And then we are, you say their powers include running or organizing conferences, and which is what they are doing now. But then when you look at the timeline and their argument today, you will have to address me on this one. If the mandate was only given on 18 June, and the argument is this, is that the conference has been planned a long time ago. Who has been planning it? On what mandate? On those kind of issues. I don't know if you want to say something before you step off.
Yes. On that specific issue, the issue is like this, my lady. I've made the submission before. If the NEC, first let's use the but for logic. But for the NEC this Monday having sanctioned an illegality and imbued the dead PEC with life, but for that, you and I would not be in this room today. So, everything else pales into insignificance. But for second stage, but for the NEC having said to us on
20th.
Wednesday, the 20th. Yes. But for them having said we must have another try at internal resolution, we wouldn't be here. We would have been before another judge on Thursday, maybe. So those are really the nuts and bolts of the matter. So the only two triggers. That's why I said this case really is an extreme case of good, well-behaved applicants. The two triggers, being Monday and Thursday, are what caused us to be here. And we've already gone through the fact that they might have other remedies about other things and buying of cars and so on is not what is before you. Maybe one day they might also say, look, this PEC also sold the building, as the leadership said, and we want to sue them. Then they must go to the action court, to the trial court. But that's got nothing to do with the issue before us here. The issue before us is crisply the following. Is this court going to come to their assistance or not in relation to undoing the decision taken on Monday by the National Office?
I'm sorry. Sorry, let me read you the letter from their attorney.
Page.
It starts at 100.
100. Oh, yes.
Because I've been asking and I'm trying to, I know I read these things and I'll find them when I give judgment. Our instructions are to record the following. The current PEC is holding office on unconstitutional and illegitimate grounds in that its term of office lapsed in February 2018. We are not aware, save for a purported attempt only on 18 June 2018, that the NEC had extended the term of office of the said PEC, and in any event we submit that any extension of office will be unconstitutional and in breach of the ANC constitution, which underscores the term of office of all elected structures. The NEC is bound by the very same constitution and cannot act contrary thereto.
Correct.
3.2, you talk about them continuing to take executive and administrative decisions, including with regard to the REC of Pitamkawa region, and they are continuing to hold themselves out as a legitimate structure. And 3.3, we are instructed that all decisions taken by the illegitimate PEC and the illegitimate are irregular and unconstitutional. They should be rescinded forthwith. And
can I invite the court to go to paragraph 4?
Yes. The matter before me, as you have correctly stated, is not about the decisions.
No.
So it's about the conference.
Exactly. And that's why paragraph 4, it says that, and let's look at it positively now, because we complain, but we also provide solution. We say in this respect, and this is what will happen if your leadership grants the relief, we respectfully ask that the ANC should ensure that there is an inclusive process towards the reconvening of a new provincial conference to be convened at a future date, a lawful one, obviously, including but not limited to the appointment of a provincial task team to oversee the processes of branch nominations, branch general meetings, and any regional conferences in preparation for provincial conference. So what they are saying there, if you read between the lines, instead of this illegal PEC doing those things, overseeing the process of branch nomination, branch general meetings, and regional conferences in preparation for a professional conference, it should be a lawful PTT.
All right, we're going to cut out of that for now, but those are live visuals straight from the South Gauteng High Court, where disgruntled NC members are seeking an urgent interdict to halt the Limpopo elective conference that was set to commence today, arguing that the current PC's time has expired. Now, Advocate Limpopo, they're representing the disgruntled members, saying that they want any decisions that were taken since February to be overturned. He also put it to the judge that there is no redress for these members should they go ahead with the conference, hence they sought a court instruction. He argued that the rights of the members, the NC members in this case, have been duly infringed because as a card-carrying member, it means there is some sort of contractual agreement between the two, meaning also that they have every right to question and to seek redress should the party constitution not be followed as alleged in this matter. He said basically there is no PEC, so the decision makers are basically running a bogus conference in Limpopo because they don't exist themselves. The judge then wanted to find out what would happen if they were to actually seek an extension of the PEC's mandate. To which Advocate Mpofu said this matter is an issue of the NEC and not why they sought the interdict. That hearing is continuing there and we'll take you back there shortly. For now, though, let's take a quick ad break.
Is now being wrongly done by the PEC. Branch general meetings, which is now wrongly done by the PEC. Any regional conferences and preparation for provincial conference. Well, all those things have now been done by the wrong people. To put it in simple
Did you
terms.
notice that they accuse you of not knowing their constitution?
No, yes, well they do that all the time and unsuccessfully. If anyone doesn't know their constitution, is them.
Well, it's attached here. Even me, I can read. I don't know. There's the interpretation and then looking at what has been written.
No, it's actually embarrassing, my lady. The person who says that is a Secretary General of the ANC, and he says somewhere that what happens in a provincial conference is that the top 6 of the province gets elected. There's no such thing. He doesn't know the constitution of his own organization. It's only a top 5. The top 6 only applies to a national structure. So if he wants a lecture on the constitution...
maybe the letter was copied and it's a copy and paste.
Cut and paste, yeah.
And again, like you, he's complained that he drafted the affidavit under extreme
Yes. No, I can offer one of my juniors can lecture him on the constitution of the ANC.
Anyway, are we done?
Just to round off, my lady, I'm really indebted with the engagement, my lady. I know it's taken time, but your ladyship had to satisfy herself. In closing, my lady, to round this whole thing off, what we have here, it's very, very, very important for us to focus the case on this dispute and on the goings on once, as I said, the light turned green on Monday. Now, Section 34, that is why in Ramakata they refer to Section 34. Section 34 says that when you have a dispute, it doesn't matter where you are, it's a right that we all have. At a particular point, remember now the lights are green, you've exhausted your remedies. To deny that person the enforcement of those rights would be to deny them of their Section 34 rights, which is we are in a constitutional democracy where there's a rule of law. So only the court can now say, now they are saying this conference is tainted by illegality. They are saying, no, this conference we ratified and what have you, all the things that they are saying. Only the court can say which of the two of us is correct. Is a PEC that is dead ratifiable? And if so, if not, rather, was Monday's decision by the
But is that decision not reviewable?
Yes, that's
the Monday decision.
Yeah, it's reviewable. That's what Froneman said, and unfortunately he was wrong. Because the fact that it's reviewable is neither here nor there.
No, but then is it not a yes or no? It is reviewable.
Reviewable under what? Paja?
No, I'm asking, is it not reviewable?
No.
The decision to extend to breathe, to use your word, to breathe the life of into the PEC, is it not reviewable?
No. That's why I said, when I did the Ramakata case, I said it's reviewable under Paja on the following grounds.
It can't be reviewed under Paja.
Well, the Constitutional Court, maybe that's correct, but Constitutional Court said that question is left open. So I won't...
For you and me.
I won't venture into that. But let's forget about Paja. Let's say under legality. For example. Yes. Under legality, obviously, you see, it's like, my lady, these tender cases. When I say what do they call those things? The structure, the procurement structure has taken a decision and awarded the tender to Mr. Nwokaitobi.
Yes.
And I come to court and I say, in the interim, on an urgent basis, stop that decision. The court can say, but that decision is reviewable, and of course it's reviewable. But the point is that that's not the question. The question is the question that your ladyship asked earlier. As you are sitting now here on a daily basis, what harm are you suffering? And that's we've already addressed that. So the question of reviewability, in theory, is not an answer either way. Because, of course, the reason why you come to court on an urgent basis for what we normally call Part A of the thing is that pending the review. So that question doesn't even arise because you yourself are saying pending the review, which means it's reviewable. So that doesn't assist the court either way. All the court has to say is, as we are speaking now, that disimpugned decision of the NEC on Monday, is it defensible or not in law? If it is, then we lose. If it is not defensible in law, then we must succeed. Because, and we strenuously argue that it is not defensible in law, the decision of Monday of the NEC. Why? Because they were denying us our right to have a fair outcome. And having failed to obtain a fair outcome from them, we have no choice but to come to you, my lady, to give us that fair outcome. That's really the long and short of it.
Thank you.
And on that basis, my lady, sorry, your ladyship again rightfully stopped me, but what I wanted to do in closing was simply to summarize some of the salient points that come from the Ramakatsa decision, the Dube. I don't know if we've handed up the Dube decision, which was the KZN one. We have another one in the Free State. Anyway, it doesn't matter. But all these cases, all of them are based on Ramakatsa. So once you've read Ramakatsa, this is my concluding remarks. That the law, as stipulated by the Constitutional Court, which is binding on this court, is simply that, one, these kinds of disputes must be dealt with as a matter of urgency in the broad sense of the word, because with every day that passes, they affect thousands and thousands of people. So it's just at a level of what they symbolize. Two, Ramakatsa says these are not matters that must be decided on technicalities, because they are inherently urgent and so on. But more importantly, Ramakatsa says that the rights, the clear rights that accrue, the clear rights from which these cases are based, derive directly from our Constitution, because we're dealing here with a sui generis type of contract. It's not a normal contract between Mr. A and Mr. B. But finally, and more importantly, it says that a court of law should not allow the perpetuation of an illegality based on these technicalities. So all in all, my lady, and with the greatest respect, to the credit of the ANC and the respondents, at no stage do they refute the undeniable fact that the term of office of the PEC expired on the 14th. If anything, they endorse that decision. My lady, I know I'm taking an indulgence, but I'll just invite your ladyship to go to paragraph 40 of their answer. I promise this is the last submission I will make. It's on page 10.
Yes.
This is all we're asking for. They say, remember, in the facts we say both the RTT and the REC and the PC had expired. They said, insofar as the region is concerned, the NEC resolved that a regional task team, RTT, be appointed as an interim measure as the mandate of the REC had expired. So they know the answer. So the question, the rhetorical question is, if you could do it for an expired REC, why did you not do it for an expired RPEC? And then Ms. Didiza, for her part, says that there was a decision taken about the regional conferences, I mean the REC, but she says specifically no decision was taken about provincial. That's on page, it's on page 6 of the DISA. I don't know what it is on the paginated papers.
Is it the answering affidavit?
Yes, DISA's affidavit is attached to the answering affidavit. It's called the confirmatory affidavit.
There's no index. Toko disease,
Oh, yes,
83.
It started 83. Paragraph 19, 88, page 88.
Yes.
She says, the National Executive Committee of the ANC met on 26-28 May, at which the NWC report dealt with the preparation towards holding conferences. The NEC resolved that the PCs should appoint RTTs where the mandate of the REC has expired. They say, here's the big one. There was no specific decision in respect of provinces. And then he says, it is however worth noting that the preparatory committee had been appointed for logistical purposes relative to Limpopo. That relates back to the Mahashule affidavit, that there was an existing preparatory.
Where are you reading?
Melo?
Paragraph?
19. So that also answers your ladyship's, it's on page 88, my lady. It answers two of your ladyship's questions. The first one is that there was no decision in respect of provinces to establish interim structures. But most importantly, it says, it is however worth noting that the preparatory committee that is now of Limpopo had been appointed for logistical purposes relative to Limpopo. In other words, we'll relate that to the Mahashule affidavit that said there was an existing PTT. So this PTT is the same.
Does she say so?
No, it's
that's the difficulty between you and me. I can't read what it's not written.
Okay, then your ladyship
She
must
simply
then
says had been appointed. When and by who, she's not saying.
yes, then your ladyship must then go to page 84.
84, it's a
84, just a few pages before the 88.
yes.
That's where she says, this links directly to the Mahashule affidavit. A preparatory committee was elected, and then further this was established to oversee the logistical arrangements of the conference. And the following members of the preparatory committee, guess what? 7.1 to 7.9, then you go to Mahashule's thing. It's the same.
It's the same affidavit.
Yes. No. It's the same preparatory committee. That's the issue. So there was no two separate committees that were selected. The DISA is telling the court that there was a preparatory committee made by the same people. The mere fact that, as your ladyship pointed out, that one spoke about 13th to the 15th of April is irrelevant, because the same preparatory committee, which had been appointed by the PEC, was allowed to continue and is now running the show.
Thank you, Mr. Mpofu.
As God pleases, my lady. Anything else we'll deal with?
It has been a long submission, but I told you I'm going to deal with agency first.
Well, my lady, we've made all our submissions.
Yes.
We'll,
Mr. Mukari. We're not adjourning. We'll adjourn after Mr. Mukar.
As God please.
Mr. Mukari.
As a court pleases, my lady, it has been a long day with long submissions by our learned friend, but I'm going to ensure that my submissions are relevant to the issue at hand, which is whether this matter is urgent or not. Rule 6, sub-rule 12, obliges an applicant who approaches court on an urgent basis position, because the point of agency is a substantive issue because it goes to the heart of whether the court can allow the applicant to jump the queue. So it's not a technicality. But let's look at what Justice Yakub meant by technicality, and your Lordship will find it in paragraph 12 of that judgment at page 7. Because in paragraph 12, Justice Yakub lists all the technicalities that were raised by the respondents in the High Court. They start from A and they go up to H. And none of this that the court regarded as technicalities relates to agency.
You say paragraph 12?
That is paragraph 12.
Yes.
Page 7. Where the court says, the High Court in upholding each of the objections raised by the respondents held that, and then he deals with each of them from paragraph A to paragraph H. And your Lordship will see that nowhere then has the court then raised that there was an issue about agency which the court then improperly or did not deal with appropriately. Why? Because the question of whether the matter is urgent is on a case-by-case basis, and it will depend on the facts of each case. So whether this case is urgent is not going to be decided on the merits that confronted the court in Ramaphosa, but it's going to be decided on the merits of this case on what the applicants have averred render the matter urgent. So that is what Rule 612 requires. They must set out the facts of their own circumstances why they should be entitled to jump the queue. And we don't see that in the founding affidavit. But our learned friend also then referred the court to paragraph 41 of the Ramaphosa judgment at page 20, where he sought to demonstrate that agency in a matter like this is self-evident. Something that we say that it is not, if you look at what the Constitutional Court said in paragraph 41 of the judgment, and this was now the judgment by Froneman J. He says the agency in this matter stems from the fact that the National Conference of the African National Congress, the 26th respondent, was scheduled for mid-December. And so the reason why he found the matter urgent, he states it in this paragraph, because the matter was already before the Constitutional Court on appeal in November in respect of a conference which was taking place in December. But here we're dealing with applicants who are in a completely different footing. So the conference, they went to court in November in respect of the conference which was taking place in December on the basis that the conference or the national conference of the ANC must take place then knowing then who actually then is entitled to be there. So he found a specific reason to find the matter urgent. And he says, in the founding papers in the Free State High Court, Bloemfontein, the appellant stressed that the National Conference will elect a leader who will also become the president of South Africa in due course. That may well be the practical reality of the political situation in the country at present, but it raises no issue that needs urgent constitutional clarification in the national or public interest. So it leaves that issue then open. Then it says the Constitution provides that the president of the country is elected by the National Assembly. The outcome of this case will have no legal or constitutional impact on that process. So then the Froneman in his judgment in paragraph 41, he discounted that as a basis then to finding the matter urgent. Then we're finally referred to, in the same judgment, to paragraph 77. And this now was the joint judgment by Musaneket, DCJ, and Jafta J. In paragraph 77, they say, whenever a conference is planned, whether it is a regional or provincial conference, the PEC must determine a cut-off date for purposes of conducting an audit process. Once that date passes, the National Audit Team must verify paid-up members of each branch intending to send delegates to the conference. So let me pause here. First, this paragraph has nothing to do with agency, nor is it any basis then to find agency. What the court was dealing with here was the context in which that matter came to the Constitutional Court on the merits that there were irregularities in branches. Then it had to deal with the process leading to the process, what is called the audit process, and it sets out that process. In this matter, your lordship will find no attack on the audit process that has taken place, and they don't even attack the audit report that was signed off by the Secretary General. So the issue does not even arise in this matter. Nowhere will your lordship find any allegation that there were irregularities in the branches because the branches were not audited, or that the delegates who were sent or who are currently in the current conference that is taking place are actually delegates who were improperly elected in the BGMs. No such allegations have been made. So clearly there is a difference, so distinguishing factors between what happened as a matter of fact in Ramakatsa to what the court is confronted with. So what then must the court do when confronted with a situation where the allegations in the founding affidavit are not sufficient to set out circumstances which render the matter urgent? Then the appropriate order is that the court strikes it from the roll. And let me deal with the second requirement. Our learned friend has said that the second requirement, he can dispose of it in 5 minutes. But that is a very important and critical requirement because it goes to the heart of whether the court can hear that matter. Whether the applicant cannot be afforded appropriate redress in due course. We understand our learned friend to be saying that no, but the appropriate remedy could only be around the 14th of June because the conference was coming, and the decision was made on the 18th of June, and the conference then was confirmed to be taking place on the 22nd of June. That is a complete mischaracterization of the requirement that is set out in Rule 6.12. The circumstances which render the matter urgent and why appropriate redress cannot be obtained in due course means that in the normal course. So it means that you must be able to say that I don't have any remedy. If this happens, the horse will have bolted and there is no remedy, whether review, whether in delict or whether in contract. I cannot be able to come to court to claim that. But our learned friend has correctly considered that review is available. And for present purposes, it doesn't matter whether that review is under PAJA or whether it is under the Constitution, Section 1C of the rule of law. But what matters is that the applicants concede that there is a review. They can review the entire conference. They can review the what they call is a decision to extend the term of office of the current PEC, which was only for 5 days. They can review those decisions. And the Constitutional Court, dealing with the matter in opposition to urban tolling, which the National Treasury was the applicant at the Constitutional Court, per Justice the Musaneke, particularly if you look at, if your lordship looks at from paragraph 15.
What's the citation?
The citation of the National Treasury versus opposition to urban tolling. We'll find the citation soon. My junior will do that. So Justice Musaneke that dealt with the issue of absence, that you will not be afforded appropriate remedy in due course. A review itself is an appropriate remedy because a review will entitle you to set aside then those decisions. And this is the appropriate remedy that the applicant has. But what is even fundamentally problematic, my lady, with the founding affidavit of the applicant is that nowhere in paragraphs 38 to 41 do they deal with that second requirement. And the leadership then pointed out to our learned friend and say that this requirement now, and our learned friend cannot point to any paragraph in the founding affidavit where it is alleged that will not be afforded appropriate remedy in due course because of 1, 2, 3. What the court is simply told, if I take Your Ladyship to paragraph of the founding affidavit, page 25. That is page 25, paragraphs 45 and 46.
Paragraph
45
yes.
and 46. In 45, we only have a bold allegation that they will suffer harm, and without explaining which harm they will suffer, because they say that, needless to say, the harm which is suffered by the applicants, other ANC members in Limpopo, naturally, not to mention the public at large, is continuous, irreparable, and increases on a daily and hourly basis until remedied by this court. But we are not told of what is that harm, because all what are told is a further argument in this regard will be advanced at the hearing. And this court, even at the hearing, were not told exactly what precisely is the irreparable harm that will be suffered by them. In paragraph 46, then they say, the applicants have no other alternative but to resort to this court for the relief sought. The balance of convenience clearly favors the granting of the application. They even rely on the balance of convenience, my lady, despite that they're seeking a final order. When case law is very clear, when you seek a final order, the balance of convenience does not arise for the applicant. That's important. The balance of convenience does not arise for the applicant, because if you are seeking a final relief, then all you have to demonstrate is a clear right, irreparable harm, and absence of alternative remedy. But the balance of convenience arises when you are seeking an interim order or an interim interdict. But the balance of convenience remain available to the respondent even where the applicant seeks a final relief. Because the applicant is able to say to the court that if the court were to grant an interdict or the relief on an urgent basis, what it means is that I will suffer severely. And let's look at the facts of this case now. And that's what the respondents are saying. And in the letter from the SG is saying that enormous time has gone in the preparation for the conference and millions of rands have been spent. Now, as we are sitting here, we know that we are now talking about the conference, my lady, which is on the second day, now at 4 o'clock. A conference that is to finish tomorrow. My junior has given me the full citation, my lady. You also have it here, yes. It is National Treasury and Others versus Opposition to Urban Tolling Alliance and Others, 2012, Volume 6. SA 223, Constitutional Court. And your Ladyship then will find, particularly from the reading, then the sequential reading starts from paragraph 46, and then 47, 48, 49, and 50, which make the point. So the balance of convenience become available to the respondent because the court then has to weigh the harm that will be caused when an application like this is going to be heard on an urgent basis, particularly where the applicant did not set out the circumstances which satisfactorily demonstrate to the court that they will not be afforded appropriate redress in due course. What the court must be satisfied about, which must be alleged in the founding affidavit, is that that redress in due course is not appropriate. So that's why Section 612 then uses the nomenclature of appropriate. So it is appropriate, a review of the decision, but what I would like to further demonstrate to your Ladyship with regard to the self-created agency, if I may go back to the first requirement, your Ladyship will see, and your Ladyship has already referred to that program for the day. This is the basis of the applicants coming to court, not on the basis that they will keep on updating the court about what is happening. That is immaterial. What they want to interdict is the conference, and they accept that the conference has commenced yesterday. As to at which item the conference is immaterial. But the fact is that the conference has started. But when they brought this application, my lady, if you look at FA1 at page 29, particularly day 1 at page 30, they were aware of the program for the day. So they can come today and say that, well, the conference is going very slow, so you can still interdict it. That cannot be the basis for that. So the fact of the matter is that they knew that the conference starts on the 22nd, and what did they do? Then they launched the application on the 23rd, on a Saturday, where they give the respondents an extremely short period, where they serve the papers afternoon with annexures coming 3:30 and saying that we must give them the answer affidavit by 6 o'clock so that we can be in court on Saturday on the second day of the conference. But they knew. And they say in paragraph 13 of their answer affidavit that they did not know. Yet then they themselves attach the very same program. Your leadership will find paragraph 13 of the founding affidavit at page 9 of the founding affidavit, and which we have refuted in the answering affidavit by Makashule, and for which they have not replied to in the replying affidavit. So we know as we are here that when they launched the application, they knew that the conference starts on the 22nd, but they set it down for the 23rd. They knew about the program of the day, then how the program is supposed to run. So they allow everybody to be there, delegates to be there, delegates to be booked, and to start the conference, and they come to court and they say that stop the continuing of the conference. That is a situation where the court has to now look at whether the applicants do not have an appropriate redress in due course. If they have it, then the court, on the balance of convenience, will then say that I cannot stop a conference for the reasons that are set out by the applicants. So, my lady, these are the two jurisdictional requirements which the applicants have not satisfied in their founding affidavit. So, authorities of the court say that if these requirements are not satisfied, then the court simply struck the matter from the law. The court does not say that there is no case to be argued at a later stage. All what the court say is that for the reasons given, the matter is not urgent. And that is precisely what Justice Museneke say in National Treasury. That does not mean that you do not have a case in review, but what must be looked at by the court is whether the review will give you substantial redress. If it does, then you cannot jump the queue. So that's precisely what Justice Museneke then is communicating in opposition to Ebentoli. Issues of that this is unconstitutional, that this is the PEC which does not exist. Our learned friends are aware that those are disputed issues. Those are issues which the court will deal with appropriately at an appropriate time. Imagine, my lady, you are confronted with an application on a Saturday in respect of a conference which is on the second day and is left with only one day, and your leadership is asked to grant a final order of a declaratory nature. Quite extraordinary and unheard of. Particularly where the respondents have been given such little time to answer. We'll understand in situations where a party comes to court on an urgent basis and seek an interim relief, because we know that the respondent will always have an opportunity to properly put its case before court. But here then we're given only few hours, and the court also is given very little time, and then the court is asked that give us a final order, stop this conference, we don't care how far it is, and then give declaratory orders and interdicts. And this must be final. And that is what then the court is told. But the court is not told why this matter is of such extreme urgency that it requires such an intrusive type of orders on an urgent basis. So, my lady, we submit that the applicants have not made out a case for urgency. All the submissions that our learned friend then was trying to converse then on the merits are the submissions.
In breaking news now, we're just going to cut out of that for now, but Zimbabwean President Emmerson Mnangagwa has survived a blast at the